to the Andhra Pradesh High Court in 2006 and served as a permanent judge from 2008, delivering over 43,000 judgments, many of which are landmark decisions. Following his retirement in 2018, he took charge as the chairperson of the AP Electricity Regulatory Commission in 2019. We are honored to have him with us today. Now I request Dwarkanand Garu to preside over the program.
Honorable Justice C.V. Nagarjuna Reddy will speak on a presentation on the doctrine of judicial precedents and its binding nature.
Since the ever ebullient, the chairman of the Bar Council of Andhra Pradesh, Mr. Damaodaram Reddy, the esteemed members of Bar Council, the members of legal fraternity, the students, ladies and gentlemen. The topic I have chosen for this session, that is doctrine of precedents and its enforceability, is purely an academic topic, so I may have to bother you by reading certain extracts. I request all of you to patiently bear with me, because without reading these extracts, the presentation will not be meaningful. The doctrine of precedent is the most pivotal jurisprudential doctrine. This is pivotal because you visualize a situation where on the same problem, in the same set of facts, there will be varied views expressed by the courts in different cases. What will be the position of the society in that case? It will lead to utter chaos and confusion. It will bring in subjectivity in decision making instead of objective adjudication of the cases. Lawyer will not know how to advise his client. Client will not know whether to litigate or not to litigate. Even a judge is in a highly confused state of mind as to how to adjudicate this case, because there will be hundreds of views expressed on the same point. The panacea of all these evils is the doctrine of precedent. It will bring certainty to the legal litigation. It will enable the lawyer to properly advise his client. It will also help client, the litigant, to choose even before he starts the litigation whether to start the litigation or not to start the litigation. And moreover, even for a judge, it gives a better clarity and better quality in adjudicating the litigation before him. And more most importantly, it brings in harmony and avoid judicial anarchy. These terms, harmony and judicial anarchy, I have not coined these two terms. This is reflected in a judgment which I am going to refer to you in due course of time. So this is why I described this doctrine of precedent as the most pivotal doctrine of jurisprudence. Then, having said so much about the precedent, what exactly is this precedent? Can any one of you tell in one sentence what is this precedent all about?
Res judicata.
Res judicata.
Legal principle of
Judgment which is binding on the courts. Judgment passed by the higher courts, courts which is binding on the all other courts are said to be called as the.
Right. You are right. Samad, the great jurist, has very aptly described what this precedent is. I can't do better than extracting his words. I quote, in a loose sense, it includes merely reported case law, which may be cited and followed by courts. In a strict sense, that case law which not only has great binding authority, but must also be followed. And next sentence is very important. In all, precedents are authorities of past decisions for future cases. This is how he described it in one sentence. They are past authorities, past decisions, authorities of past decisions for future cases. It must be reported, cited and followed by courts. Then the next question would be, how to decipher this precedent? That's a very, very not only important but also challenging task. In Bir Singh versus Union of India, AIR 2019 Supreme Court 2446, AIR 2019 Supreme Court 2446, the Supreme Court held, I quote, before construing the doctrine of precedent, it is prerequisite to know what exactly in a judgment is binding. So how do you know that? Is again a challenge. The doctrine of precedent is not a standalone doctrine. The doctrine of precedent is not a standalone doctrine. It has 5 different doctrines, which you may call it concomitant doctrines or core doctrines. There are 5 some, and I will try to explain each one of them. Can any one of you say what these doctrines, sub-doctrines are?
binding precedent.
Okay. The first one is ratio decidendi. This is a Latin phrase which in English means reason or rational for the decision. When a decision is given, it should be supported by reasons which are otherwise also called rational. In Jayanti Verma versus Union of India, AIR 2018 Supreme Court 1079, the Supreme Court held that a judgment not containing proper reasons is not an authority to be followed. In this context, I am reminded of my own personal experience. When I was sharing bench with the then Honorable Chief Justice, the great Justice Singhvi, G.S. Singhvi. A case came up before us. It was a writ appeal filed by the government against the judgment of a learned single judge. It ran into about 116 pages. So previous night, I had to burn my midnight oil. I went through the entire judgment. I was at a loss to know why the learned judge has allowed the writ petition. When the writ appeal came up before the bench, when the government leader started arguing, I stopped him with the permission of the Honorable Chief Justice and asked the other side counsel, who appeared to be a woman advocate, senior woman advocate. I asked her, so and so, please show us the reasons in the judgment which support the decision, final decision. Back came reply, sorry my lord, I am not able to find reasons. I said, I am also unable to find, that's why I asked you this question. I have said this not to denigrate the learned judge, to say that a judgment, whether it may run to 100 pages or 200 pages, it is of no value if it does not contain reasons. That's why in Jayant Verma vs. Union of India, AR 2018 Supreme Court 1079, the Supreme Court held that a judgment not containing proper reasons is not an authority to be followed. In another judgment, Assistant Commissioner, Commercial Tax Department vs. Shukla and Brothers, 2010, 4 Supreme Court cases 785, the Supreme Court described the reasons in a judgment as soul of orders. Soul, Atma, soul of orders. Reasons constitute soul of orders. I recall a hilarious judgment of an English court. That's a judgment rendered in a money recovery suit. The defendant's defense is very, very simple, cryptic. If God be my witness, I do not owe and I need not pay. This is the defense. If God be my witness, I do not owe money to the plaintiff. I do not owe, I need not pay. Then the judgment came. Don't be shocked. He is not. This is the judgment. He is not. Who is not?
God
is not your witness. He is not. You do. Said I owe. I do not owe. You do. You do owe. You pay. Believe me, this is the judgment. So, can this judgment be relied upon as a precedent in subsequent cases? So, this is an extreme example of a judgment not containing reasons. Of course, there are various other judgments which for various reasons may not contain reasons or proper reasons. So, all those judgments would not qualify for being called as precedent, because it does not contain ratio. Ratio, as I already said, ratio is nothing but reasons are rational for the decision. Then how to call out a ratio? Can anyone answer? How to call out a ratio? Alright, I'll ask you one simple question unrelated to law. How will you extract butter? How will you extract butter? You extract butter by churning curds, isn't it? The same way as you extract butter by churning curds, you isolate ratio by analyzing the judgment. You have to analyze the judgment. How you analyze? The Supreme Court said this in Fida Hussain versus Moradabad Development Authority, 2011-12 Supreme Court cases 615. I repeat the citation, 2011-12 SCC 615. There are multiple authorities. You need not bother about them. I am just giving certain important decisions, and you can collect various other decisions also, either preceding these judgments or following these judgments. The Supreme Court held in this case that a decision of a court on specific facts, does not operate as a precedent in future cases. If a decision turns on the particular facts of that case, that will not be a precedent for future cases. And this is very important. Only the principles of law, number one, only the principles of law that emanate from a judgment which have aided in reaching a conclusion of the problem are binding principles. So it has three aspects or three postulates. One is there must be a principle of law that emanates from the judgment, and this principle of law was taken aid of in reaching the decision, and this decision was reached in a particular set of facts of the case. So three important aspects. There must be a statement of law, principle of law that has helped the court in taking a decision, and that decision is on a particular problem or facts. These three are essential features of a ratio, which then only be relied upon as a precedent. So that's why this ratio decidendi is a very, very important sub-doctrine or concomitant doctrine in applying the doctrine of precedent. And I give you an example. Supreme Court said a judgment based on specific facts does not constitute a precedent. I'll give you an example, simple example. Suppose in a promissory note suit for recovery of money based on a promissory note, the plaintiff was not able to prove passing of consideration. So based on that set of facts, the judgment was rendered, which was confirmed by High Court and also Supreme Court. In a subsequent suit where the plaintiff was able to prove passing consideration, the previous judgment will not operate as a precedent, because the material facts differ from the previous case to the subsequent case. That's why I said three postulates. The statement of law which influenced the decision based on specific those set of facts. If you have similar set of facts, then this judgment would operate as a precedent. There is another judgment, Union of India versus Dhanwant Devi, 1996 6 Supreme Court cases, page 44. It was held, I quote, "It is not everything said by a judge while giving judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided, and for this reason it is important to analyze the decision and isolate from it the ratio decidendi." That's why I gave you the example of butter, extracting of butter, best example. You isolate butter from the butter curds or buttermilk, whatever. Similarly, you isolate the ratio part of it from the entire judgment, so that the other part of the remaining part of the judgment will not be considered as precedent. Only that part which constituted ratio would be treated as the binding precedent and the courts. It is further stated that according to a well-settled theory, every decision contains three basic postulates: finding of material facts, statement of principles of law applicable to the legal problems disclosed by the facts, and judgment based on the combined effect of the above, that is, the material facts and principle of law. Taken together, the judgment will be derived. And a decision is only an authority for what it actually decided. This is one of the most important principles while understanding the doctrine of precedent. A decision is only an authority for what it actually decides. What is essence in a decision is its ratio and not every observation found therein. I'll give you an example for this also. Assuming that a particular statutory provision in an act was challenged before a constitutional court, either High Court or Supreme Court. Arguments were advanced in respect of that provision and also with relation to various other provisions. And in the course of deciding the matter, the court will not only deal with that particular provision which is assigned before the court, but also various other provisions which were not subject matter of issue before the court. In a subsequent case where the other provisions which were not assigned in the previous case were subject matter of the dispute, the observations or findings made by the court in the previous case with respect to the other provisions will not be a binding precedent in the subsequent case. In ICICI Bank versus Municipal Corporation of Greater Bombay, 2005-6 Supreme Court cases 404, it was said that a judgment cannot be read as if it is a statute. This is also one other important principle. It should be understood in the context in which it is decided. It is not every observation made or finding rendered on facts of that case that constitutes a ratio and consequently a binding precedent. This is also very, very notable observation because habitually we find lawyers picking out certain stay sentences from a judgment and reading out to the court. That should not be done because that particular observation may not have arisen in respect of an issue which specifically arose before the court. So instead of doing that, what the lawyer has to do is he has to read out the relevant portions of the judgment. In my opinion, while writing a judgment is an art, writing a judgment by a judge is an art. Reading out that judgment on which a lawyer relies upon in the court is also an art, equally an art. Because you have to focus on mainly three aspects while reading out the judgment: material facts, statement of law, and conclusion. Only with reference to these, you have to explain to the court how the case arose, what actually was the dispute that is revealed from the material facts, and then what is the law governing the field in respect of those facts, and then what was the decision taken by the court in that judgment. So these are the three most important aspects which you need to briefly point out to the court instead of just reading a head note. I tell you, this is a very, very unhealthy habit. Reading a head note is a very unhealthy practice because who is the author of the head note? Who is the author of the head note? Editor is the author of the head note. Judge is not the author of the head note. And most of you must be knowing the modern day thumbnails. Thumbnails, you know?
Yes.
What is thumbnail? Thumbnail.
The picture.
So, in every video, before you open it, you will have very attractive thumbnail. It will compel you to open the video and watch it. Finally, to your disappointment, there will be nothing in the main content of the video. He says, so and so has gone to jail. And so is definitely going to be arrested. So on and so forth. So many things. It fools you day in and day out. Every day we get fooled. Because we have some fond hope. No, this may be correct. Yesterday it may be, it may not be, today it may be correct. So head note is like a thumbnail. Whatever the editor understands, he may not deliberately do it, but in his own understanding, he tries to interpretation the judgment and prepare the head note. So please never read a head note. As I told you, briefly read the material facts and then the statement of law contained in the judgment and the final decision. Then the court will know whether this judgment is relevant or not relevant. Because I have seen many judges, lawyers, in my days of practice, very senior lawyers, spreading the books, those days all journals, printed journals, spreading all the books as if to scare the judge first. Some of the judges, seeing those books, will adjourn the cases. And some pretext are there. So, a senior lawyer, I still remember, he has brought about maybe 50 books. Of course, I have not counted exactly, maybe around 50 in number. From this side, this end of the tables, 3 or 4 tables full length, up to the other end. Then he picks out each judgment, each book, and then he starts reading head note and say, sorry sir, sorry my lord, this is not relevant. So out of 50 books, he must have said 45 books are not relevant. Then I didn't know why he brought all those books.
Wasting of time.
So this is maybe obviously to scare the judge, or maybe because of his own lack of understanding, lack of proper preparation of the case. Whatever perhaps sometimes the seniors may not have much time to concentrate on. Whatever juniors suggest, he will keep all those books and then he will realize on his feet that this is not relevant. He will keep it aside. So don't do that. Reading a judgment in office is a very, very important exercise so that you can save the court's time and you can also win the confidence of the judge. So next, this is what ratio decision is about. And then next supporting document is arbiter dicta. We may call it arbiter dictum also. Arbiter dictum is singular, arbiter dicta is plural. In Director of Settlements of Andhra Pradesh versus M.R. Apparao, 2002 for SCC 638, the Supreme Court held, it distinguished between ratio decidendi and arbiter dicta. An obiter dictum, as distinguished from a ratio decidendi, is an observation by the court on a legal question suggested in the case before it, but not arising in such manner as to require a decision. I repeat the same example. In respect of the challenge to the constitutional virus of a particular provision, that was the issue arising. Other provisions did not arise, but still there will be some observations or findings. Those observations will not become a binding precedent because it does not constitute ratio. On the contrary, it will constitute obiter dictum. The court further held, in the context of explaining what is binding is the ratio of the decision and not any finding of facts. It is the principle found out upon the reading of a judgment as a whole, in the light of the questions before the court, that forms the ratio and not any particular word or sentence. A judgment of the court has to be read in the context of the questions which arose for consideration in the case in which judgment was delivered. In a statute, because in a judgment, every sentence or every word may not have much significance, may not contribute to the value of precedent, unlike a statute. Because in a statute,